What do a former Klansman, a combative opera-loving conservative, and a privacy-obsessed Boston lawyer have in common? They all sat on the U.S. Supreme Court and each left an indelible mark on American law and brought some serious personality to the bench. I've always been fascinated by these three justices. As a conservative, it might surprise people that two were Democrats and one was a Republican, but all three shaped how I think about the court, constitutional law, and our country's direction. Stick around. I think you'll come away seeing constitutional law in a new light too. Today, let's meet Justice Hugo Black, Justice Antonin Scalia, and Justice Brandeis. We'll explore their judicial philosophies, highlight one or two key cases, and share a few personal tidbits that prove even Supreme Court justices can be colorful characters. By the end, you'll see why these three justices are legends in American jurisprudence. Let's jump in. Justice Hugo Black, maybe number one on my list of favorite Supreme Court justices. Hugo Black was absolutely serious about the First Amendment, literally. He famously carried a pocket constitution and believed that Congress shall make no law abridging the freedom of speech meant exactly what it says, no law. In other words, Black was a First Amendment fundamentalist. If a law even smelled like it restricted speech or press, Justice Black's instinct was to strike it down. He was considered a First Amendment absolutist, often declaring no law means no law when it came to free speech. This philosophy led him to take bold stands, like dissenting when the court upheld convictions of Communist Party leaders for their rhetoric in Dennis v. United States in 1951. Black thought even unpopular political speech, however radical, was protected by the First Amendment. And near the end of his career, he didn't waver. In the famous Pentagon Papers case, Black wrote an opinion rejecting the government's attempt to censor the press, vehemently opposing any prior restraint on publishing classified documents. To Black, the press had to be free to inform the people, period. Yet, Hugo Black's legacy is not without controversy and an inspiring twist. Early in his political life in Alabama, Black joined the Ku Klux Klan, a sadly common move for Southern politicians of his era. This affiliation was exposed when he was appointed to the Supreme Court in 1937, causing a public uproar. Black quickly went on national radio to renounce the KKK, explaining that he had resigned from the group and disavowed its beliefs years before. He then proceeded to prove his change of heart on the court. In fact, the transformation gave rise to a joking rhyme. As a young man, Hugo Black wore white robes and scared black people. As an older man, he wore black robes and scared white people. The joke underscored that Justice Black became a staunch supporter of civil rights and liberties, often unnerving the old guard. He served 34 years on the court and was an intellectual leader, helping to apply the Bill of Rights to the states and championing individual freedoms. What a guy. So yes, Hugo Black started with a checkered past, but he redeemed it by becoming one of the First Amendment's fiercest defenders. When it came to free speech, Justice Black's message was uncompromising. No law means no law. Next up, Justice Scalia. The conservative icon who loved the Constitution, the opera, and a good debate, often all at once. Appointed in 1986, Scalia made it his mission to champion originalism, the idea that the Constitution should be interpreted according to its original meaning and text. He was a brilliant writer and wasn't shy about it. Scalia viewed himself as a faithful guardian of the Constitution's words, even if that led to results he personally disliked. For example, as a devout Italian-American Catholic and patriotic veteran, Scalia surely wasn't a fan of burning the American flag, but in Texas v. Johnson in 1989, he voted to protect flag burning as free speech because the First Amendment's text and tradition compelled that result. Principle over personal preference was his credo. If you're going to be a good and faithful judge, Scalia explained, you have to resign yourself to the fact that you're not always going to like the conclusions you reach. In other words, the law comes first, not feelings. This integrity won Scalia respect even from those who disagreed with him. Scalia's legal fingerprints are on many landmark cases. He wrote the majority opinion in District of Columbia v. Heller in 2008, triumphantly restoring the Second Amendment as protecting an individual right to own firearms for self-defense. To craft that decision, Scalia led the reader on a grand tour of history, parsing 18th century phrases and founding era practices, a true originalist tour de force. His opinions could be as entertaining as they were influential. He taught me how to be a better legal writer. Scalia was notorious, in a fun way, for his zinger-laden writing style. He would lob memorable insults and obscure quips that sent readers scurrying. In one dissent, he blasted his colleagues' reasoning as interpretive jiggery-pokery. In another, he dismissed an argument as pure applesauce. He even derided a legal reasoning test as argle-bargle. No one could turn a phrase quite like Scalia. But despite the verbal fireworks on the page, Scalia was known for warm friendships off the bench, most famously with the liberal Justice Ruth Bader Ginsburg. "I attack ideas. I don't attack people," Scalia said. Some very good people have some very bad ideas. Boy, if we could just repeat that phrase a few hundred times today. This ability to separate fierce disagreement from personal animosity is what made Scalia a beloved figure to many. Whether you cheered or booed his judicial positions, there's no denying Scalia's outsized impact on the court. He made originalism mainstream and proved that even Supreme Court opinions can be a must-read. Love him or not, Antonin Scalia kept things interesting and utterly principled at the Supreme Court. Finally, let's turn to Justice Brandeis, a progressive era hero often nicknamed the People's Lawyer. Brandeis, appointed in 1916, was the first Jewish American to serve on the Supreme Court, and he arrived with a reputation for fighting the powerful on behalf of the average citizen. If Black was a First Amendment absolutist and Scalia an originalist, Brandeis can be thought of as the prophet of privacy, and a pretty eloquent free speech defender to boot. Long before he became a justice, Brandeis literally wrote the book, or rather the law review article on privacy. In 1890, he co-authored The Right to Privacy, a seminal Harvard law review piece that argued people have a fundamental right to be left alone. This was visionary stuff in an age of newspapers and nascent cameras, and it laid the groundwork for modern privacy law. Decades later, on the Supreme Court, Brandeis continued to champion that very idea. In Olmstead v. United States in 1928, a Prohibition-era case about government wiretapping, Brandeis penned a famous dissent warning that advancing technology could threaten personal liberty. He wrote that the makers of our Constitution had conferred, as against the government, the right to be let alone, the most comprehensive of rights and the most valued by civilized men. In other words, our privacy is fundamental, and the government snooping on telephone calls without a warrant violated that sacred right. Brandeis's plea fell on deaf ears at the time. The court majority allowed the wiretaps. But his dissent proved prophetic. It inspired later courts to require warrants for electronic eavesdropping, vindicating Brandeis's view that privacy deserves vigilant protection. Today, when you hear about the right to privacy in debates, from data security to reproductive freedom, Justice Brandeis's ideas are a big part of that story. Brandeis also evolved into a towering defender of free speech. Interestingly, he wasn't always an absolutist on speech in his early years, but it was World War I and its aftermath that changed his perspective. By 1927, in Whitney v. California, Justice Brandeis wrote a concurring opinion that has since been hailed as one of the greatest articulations of why free speech matters. Brandeis acknowledged that the founders believed freedom to think as you will and to speak as you think are means indispensable to the discovery of spread of political truth, that the greatest menace to freedom is an inert people, that public discussion is a political duty. He argued that more speech, more debate, more ideas is the cure for dangerous or evil speech, not enforced silence. His famous line, "The fitting remedy for evil counsels is good ones." Essentially, the answer to bad speech is not censorship, but better speech. This counter-speech doctrine was ahead of its time, and it laid the intellectual foundation for the robust free speech protections we cherish today. In later cases, the court would echo Brandeis by affirming that political discussion is essential to the security of the republic. Brandeis lived to see some of his ideas triumph, and he retired in 1939, having helped steer the court toward both greater civil liberties and a cautious skepticism of concentrated power in government and in business. And yes, Justice Brandeis had a lighter side as well. He was cerebral and serious on the bench, but he could wield a sharp wit when provoked. Consider an anecdote from his law school days at Harvard. An anti-Semitic professor once told Brandeis, "Mr. Brandeis, you must understand that a pig and a bird do not sit together to eat." The young Brandeis, without missing a beat, replied calmly, "Don't worry, Professor, I'll fly away." On another occasion, when the same professor tried to insult him by saying he would choose wisdom over money, Brandeis deadpanned, "Each of us takes what he doesn't have." These early tales hint at Brandeis's poise and quiet confidence. As a justice, Brandeis was known for his painstaking craftsmanship in opinions and a habit of intense research. The Brandeis Brief, packed with facts and data, became a model of legal argument because of him. He was a man of principle, but also immense heart, often guided by a desire for a sense of social justice and human dignity. It's no wonder that even a conservative admirer like myself can tip my hat to Brandeis. His contributions to privacy rights and free expression transcend ideology. He showed that defending liberty isn't just a liberal or a conservative thing, it's an American thing. So there you have it. 3 Supreme Court legends, 3 distinct philosophies, plenty of personality, 3 justices with considerably differing political ideologies and who each benefited the rule of law in our constitutional tradition immensely. Hugo Black taught us that the First Amendment's words are to be taken seriously. No law really means no law, and that even someone with a flawed past can become a great defender of freedom. Antonin Scalia reminded us that the Constitution isn't a mere suggestion, it's the supreme law with an original meaning to uphold, and he showed that intellectual rigor can come with a side of wit. Who else could get jiggery-pokery into a Supreme Court opinion? Justice Brandeis showed how the law can protect the right to be let alone, warning against government overreach before most people even imagine the threats of modern technology. And he eloquently argued that the antidote to hateful speech is more speech spoken by courageous citizens like you. Each of these justices left a legacy in landmark cases and legal principles, from Black's stance in New York Times v. United States, the Pentagon Papers, to Scalia's Heller opinion on gun rights, to Justice Brandeis's Whitney concurrence on free speech. But beyond the cases, it's their judicial philosophies and personal character that make them fascinating figures. They were passionate, sometimes controversial, often principled to a fault, and they helped shape the constitutional landscape we all live in today. If you're looking for inspiration or just a good story, you could do worse than the justice who read the Constitution literally, the one who wielded a sharp pen and loved a good argument, and the one who fought for your right to privacy before you even knew you needed it. These men were more than just judges in robes. They were characters on the stage of American history. And now, armed with a few of their stories and quotes, you can appreciate the Supreme Court not just as an abstract institution, but as a human drama with thinkers like Black, Scalia, and Brandeis taking their turns. I'm Benjamin Barr, and I appreciate you joining us here today. My job as a constitutional litigator is to give you the tools necessary to resolve constitutional puzzles of the day. I'd sure appreciate it if you take the moment to like and subscribe. It helps with our educational project. And I'll be sure to see you next week as we explore yet another constitutional controversy.